I am attorney Marie-Chris Bathan Lasco. This is my virtual classroom. Welcome to my YouTube channel. In this channel, I shall aim to simplify the law. I will discuss concepts and principles of law in under 10 minutes. Hi everyone! I know it's been a while since I've uploaded video lectures. I have been very busy. So for the series of lectures that I will be uploading in the days to come, I will be discussing about defective contracts. So of course, we start this off with the least defective contract, and that is your rescissible contract. So let's start the video lecture now. So the first defective contract, meaning the least defective of them, is your rescissible contracts. Now, let's look at 1380. 1380 says, contracts validly agreed upon may be rescinded in cases established by law. Now, when you read that, you read the first part. It says contracts validly agreed upon. In other words, it already gives you the first requisite for rescission or for one to be classified as rescissible contracts. That the contract must be, at the very beginning, a valid contract or at least a voidable one. Because a voidable contract is valid until it is annulled. Okay? The second requisite is economic prejudice or lesion. Rescission is actually a remedy given by law to persons who are economically prejudiced by a contract, or we call it lesion. That's the second requisite. The third requisite is that it requires mutual restitution. So if you ask for rescission, then you must be able to return whatever you have received by virtue of such contract. So those are the three requisites. Again, first, that it must, in the beginning, of course, it should have been valid or at least voidable contract. Second is that there's economic prejudice or lesion. Third is mutual restitution. If you can recall, you're actually no longer alien to the term rescission. You have also already encountered the term under 1191. Now, the rescission under 1191, or otherwise called as resolution, is actually different from the rescission under 1380. Okay? What is the difference between the two? First, the rescission under 1380 is rescission based on lesion or economic prejudice. The rescission rather, in 1191 is based on non-performance or non-fulfillment. So the grounds by which you use when you file an action for rescission under 1380 and 1191, they are different. Second is that in 1380, the action is instituted either by a contracting party or by third persons. While in 1191, rescission is instituted only by the injured party in the contract. A third difference between the two is that under 1380 rescission, the courts are not granted the right to give a term or a period for which the other party will comply. Because again, it's not about non-performance or non-fulfillment. While in 1191, the courts may grant a term or a period. And based on that third difference, that tells you then that the non-performance or non-fulfillment is not important or essential in 1380, but it is important or essential in 1191. So these are the four distinctions or differences between 1380 rather, and 1191 rescission. Now, supposing both parties in a contract mutually agree to cancel the contract. Is that properly called rescission? Technically, no, that's not rescission. That is just mutual backing out of a contract. Can you rescind a void contract? No, you cannot. Why? Because again, it fails in the first requisite. It lacks the first requisite, which is that it must be valid in the beginning. And when you say it's a void contract, that means it does not exist. So how can you rescind a contract that does not exist? Okay, so you read UFC versus CA because there the Supreme Court clearly explained the difference between rescission under this chapter and rescission under 1191. Okay, now let's move on to 1381. 1381 enumerates the different types or kinds of rescissible contracts. First, those which are entered into by guardians whenever the wards whom they represent suffer lesion by more than 1/4 of the value of the things which are the object thereof. Second, those agreed upon in representation of absentees if the latter suffer the lesion stated in the preceding number, meaning still the same, more than 1/4 of the value of the things which are the object thereof. Third, those undertaken in front of creditors when the latter cannot in any other manner collect claims due them. Fourth, those which refer to things under litigation if they have been entered into by the defendant without the knowledge and approval of the litigants or of competent judicial authority. And lastly, all other contracts specially declared by law that are subject to rescission. Now, for number 1 and number 2, we can discuss that together. So it talks about lesion, and I have been mentioning this. Lesion is the economic prejudice or the financial disadvantage of one of the parties to a contract, which basically is referring rather to your ward or your absentees. Now, when you talk about wards or absentees, wards cannot enter into contracts. Absentees also could not because their whereabouts are known. And that is why a representative comes in, a guardian comes in to take care of their affairs. Now, to protect those wards or absentees, this is a remedy that is given to them. If and when their whereabouts are now known for absentees and for wards, if they attain the age of majority, they can examine the contracts entered into by their guardians, and if they see that they actually suffered lesion by virtue of the contracts entered into by their guardians, then they may ask for the rescission of the contract. Now let's talk about the provision which says that it is a rescissible contract if the ward or the absentee suffers lesion by more than 1/4. Now let's illustrate that. What is this more than 1/4? How do we know it's more than 1/4? So let's take, for example, a ward or a minor. A minor, let's say, inherits several properties because his parents unfortunately died due to an unfortunate accident. So let's say this minor was able to inherit a house that was used by the parents to be rented out. Okay. Now let's say the guardian now assumes the renting out of such a house. So supposing the guardian entered into a rental contract and the guardian pegged the rental was pegged at 75,000 per month. Okay. But when you look at the market with the size of the house, with the area of the house, taking into consideration the location of the house, it should have been rented out for 100,000 per month. So the market says it should have been 100,000. So how then do we compute lesion? If there is lesion in this example, it says more than 1/4. Now, where do we get the basis of a 1/4? You look at this. How much is 1/4 of 100,000? It is 25,000. So the law therefore says that if the ward, okay, or the absentee suffers lesion by more than 1/4 or more than the 25,000, then when he comes of age, he can ask that that contract be rescinded. Now look at our example. How much was the economic prejudice? It's 25,000. Okay? It is exactly 1/4. So is this rescissible? No, it's not, because the law says it must be more than 1/4. So if, for example, instead of 75,000, it was rented out only for 60,000, how much is the economic disadvantage or prejudice? It's 40,000. Is it more than 1/4? More than 25? Yes. Can that be rescinded? This time, yes. So that is what is meant by more than 1/4, the value. So that's number 1 and number 2. Third, those undertaken in fraud of creditors when the latter cannot in any other manner collect the claims due them. This, in fact, is no longer new to you. You have already encountered this under remedy of the creditors. This is action Pauliana. So if you can still remember, the first remedy of the creditor is to exact fulfillment. If he cannot exact fulfillment, then he will attach the properties of your debtor. If he cannot do so, then you have action subrogatoria, and then after that is action Pauliana. So this is basically the rescission that we're talking about. And that's why we mentioned earlier that contracting party or a third person may file an action to rescind if it causes them economic prejudice, just like in the case of creditors who are defrauded by the debtors. Fourth type, things in litigation. So let's give an example. Supposing A sues B for recovery of a specific car. Okay. Now, pending litigation, B sells the car without asking permission from the court or without the approval of A. If A wins, then A can rescind the contract of sale that was entered into by B. That is what is meant by the fourth type. And of course, the fifth type, meaning all other contracts that are declared by law as rescissible, like Article 1098 on partition, 1189 on results of deterioration, 1526, 1534, the rights given to an unpaid seller, and 1539, sale of real estate. Now, apart from the 5, actually under 1381, you also have the 6th type. That's 1382. What is 1382? It says, payments made in a state of insolvency for obligations to whose fulfillment the debtor could not be compelled at the time they were affected are also rescissible. In short, these are what you call premature payments made in a state of insolvency. So what are the requisites? The debtor payer must have been insolvent. Now, is it needed that he be judicially declared an insolvent? No, the law does not require that. And second, the debt was not yet due and demandable. Okay? So, for example, A is the debtor. A owes X and A also owes Y. Okay? The debt of A to X is due on August 12, 2020. The debt of A to Y is due on, what's the date today? Let's just say March 20, 2020. Okay. Now, supposing A is insolvent, let's just say this is only for 50,000 and this also is for 50,000. Okay. A is insolvent. Again, we said he need not be judicially declared as such. Now, if A pays X, okay, the law tells you that that payment may be rescinded by Y. Why is that? Because it's a premature payment. And it will disadvantage. Why? Because the debt in his favor is already due and demandable. But A paid X his debt when such debt is not yet due and demandable. And at the same time, A is insolvent. So that is what is meant by 1382. Premature payments in the state or in a state of insolvency. Okay? Now, through this discussion, I have already mentioned several characteristics, but let us go through them one by one. Characteristics of rescissible contracts. So first, their defect consists in injury or damage either to one of the contracting parties or to third persons, just like when the creditors, the defrauded creditors, will file an action for rescission for a contract entered into by the debtor. Second characteristic, we've also mentioned this, is that this is a contract that is valid before it is rescinded. Third, they can be attacked directly only and not collaterally. Fourth, they can be attacked either by a contracting party, as we mentioned, or by a third person who is injured or defrauded. Again, we mentioned that already. Fifth, they can be convalidated only by prescription, not by ratification. In other words, the parties affected by the economic prejudice cannot say that they are waiving their right to file an action to rescind because they cannot ratify it. They can convalidate it only by prescription. In other words, if the prescriptive period will lapse without them having availed of the remedy, then that's the only time it is validated. It cannot be validated via or by ratification. Okay? Now, another characteristic is actually in 1383. What does it say? It says the action for rescission is subsidiary. What does that mean? It means that it is not a principal remedy. You use that remedy only if you have exhausted all other remedies available to you. It cannot be instituted except when the party suffering damage, as we mentioned, has no other legal means to obtain reparation for the same. So in fact, we've mentioned this in a previous case during class where the creditor right away filed an action to rescind the donation of a parcel of land, but the court found out that there were other parcels of land that he could have attached. It was not necessary to ask for rescission right away because again, it is a subsidiary remedy. Okay. 1385, as we mentioned also before, it is required that if you ask for rescission, then you must be able to give back whatever you may have received by virtue of the contract. And that is what we call mutual restitution. Because you have to put the things back to the way they were before the contract was entered into. So 1385 says rescission creates the obligation to return the things which were the object of the contract together with their fruits and the price with its interest. Consequently, it can be carried out only when he who demands rescission can return whatever he may be obliged to restore. So you cannot ask for rescission if you can no longer restore or return what you have received by virtue of the contract. Second paragraph, neither shall rescission take place when the things which are the object of the contract are legally in the possession of third parties who did not act in bad faith. Why? Because third parties are also protected so long as they are in good faith. They cannot be punished for the things that may have that was done by the other contracting party. Again, so long as they are in good faith. But of course, if that is so and it cannot be returned, you may ask for indemnity for damages for the person causing the loss. Now, we mentioned about prescription because we said that it cannot be ratified, but it cannot be validated or convalidated by ratification, but it can be convalidated by prescription. So what is the prescriptive period? The prescriptive period is 4 years. 4 years, so the general rule, 4 years from the time the contract has been entered into, but for persons under guardianship and for absentees, the period of 4 years shall not begin until the termination of the former's incapacity or until the domicile of the latter is known. Okay, so 1384 tells you that rescission shall be only to the extent necessary to cover the damages caused. So if the damage caused is, let's say, only to the extent of 50,000, then you don't have to rescind the entire value of 100,000. You rescind only to that extent. That will cover the damage that was caused. Now, 1387 talks about presumptions of fraud. So, the 1387 talks about when you presume that there is fraud that is committed, if it is an onerous contract or if it is a gratuitous contract. So, 1387, all contracts by virtue of which the debtor alienates property by gratuitous title are presumed to have been entered into in fraud of creditors when the donor did not reserve sufficient property to pay all the debts contracted before the donation. So if there was a donation that was made and you had debts prior to that donation and you did not reserve sufficient properties for those, then the presumption is that is fraudulent, that the gratuitous donation is fraudulent. But how about for onerous donations? For onerous donations, there is the presumption of fraud. You find it in the second paragraph. Alienations by onerous title are also presumed fraudulent when made by persons against whom some judgment has been issued. The decision or attachment need not refer to the property alienated and need not have been obtained by the party seeking the rescission. So let me give you an example, okay, so that it will be clear. So for onerous alienations, there is the presumption of fraud if there was already a judgment against you. So for example, there's already a judgment against A, okay? And A sells a parcel of land, okay, to X. But the case here was A versus Y. And this parcel of land is not in any way connected with this case. So this parcel of land is different. The case between A versus Y, where A has lost this case, this has nothing to do with the parcel of land that was sold. Okay? What does the law say? Is the sale of A to X fraudulent? The law says yes, because it says the decision or attachment need not even refer to the property alienated and need not have been obtained by the party seeking the rescission. So, this sale is already presumed fraudulent for onerous alienations. Onerous because this is a sale. Okay? But of course, these are just presumptions. And by presumptions, of course, these are disputable. So if A can prove that it was not done to defraud Y, then the contract may not be rescinded. These are just presumptions. Okay? So of course, you have to read Oria versus mimicking, because those will give you examples of badges of fraud. Okay? And of course, 1388, okay, the only article that I missed, 1388. Whoever acquires in bad faith the things alienated in fraud of creditors shall indemnify the latter for damages suffered by them on account of the alienation whenever due to any cause it should be impossible for him to return them.
if you remember earlier on, we said that if the thing that is object of the contract is already in the hands of the third person, then you can no longer ask that that thing be given back to you, even though you suffered economic prejudice. But what can you do? You may ask for damages against the person who caused the loss. But this is true only if the third person acted in good faith. If that third person acted in good faith, then you cannot ask that the thing be returned. But 1388 tells you what is your remedy if you are the person being prejudiced by the contract, you suffer lesion, or you were defrauded, and you want to ask for rescission. And you can prove, because you have to prove that the third person is in bad faith. If you can prove that the third person is in bad faith, then you may ask for the return. If the third person also can no longer return, it is impossible for him to return, then he is liable for damages. And it says there, second paragraph, if there are two or more alienations, the first acquirer shall be liable first, and so on successively. Okay? So that ends our video lecture for rescissible contracts.
So, if you find this video helpful, please click like, subscribe, and that notification bell so that you will be notified of new video uploads. Thank you for watching. See you next time in MBL Classroom.